I'm going to read a court order that we got today from the Fourth Circuit Court of Appeals. It's about 2 p.m. West Coast time on Thursday, April 17th. The Fourth Circuit Court of Appeals rejected the Department of Justice's request to block lower court orders that the Trump administration facilitate the release of wrongly deported immigrant Kilmar Abrego Garcia. It's a short order. It was written by Judge Harvey Wilkinson III, who was appointed to the bench by Ronald Reagan. He's been around for a while. It is a stunning rejection of Donald Trump in the harshest of terms. Upon review of the government's motion, the court denies the motion for an emergency stay pending appeal and for a writ of mandamus. The relief the government is requesting is both extraordinary and premature. While we fully respect the executive's robust assertion of its Article 2 powers, we shall not micromanage the efforts of a fine district judge attempting to implement the Supreme Court's recent decision. It is difficult in some cases to get to the very heart of the matter, but in this case, it is not hard at all. The government is asserting the right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, that there is nothing that can be done. This should be shocking, not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Mr. Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident of its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Requiring that the government prove by a preponderance of evidence that the alien is no longer entitled to such a withholding of removal order. Moreover, the government has conceded that Mr. Abrego Garcia was wrongly or mistakenly deported. Why then should it not make what was wrong right? The Supreme Court's decision remains, as always, our guidepost. That decision rightly requires the lower federal courts to give, quote, due regard for the deference owed to the executive branch in the conduct of foreign affairs, close quote. That would allow sensitive diplomatic negotiations to be removed from public view. It would also recognize as well that the facilitation of Mr. Abrego Garcia's return leaves the executive branch with options in the execution to which the courts, in accordance with the Supreme Court's decision, should extend genuine deference. That decision struck a balance that does not permit lower courts to leave Article 2 by the wayside. The Supreme Court decision does not, however, allow the government to do essentially nothing. It requires the government to facilitate Mr. Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Facilitate is an active verb. It requires that steps be taken, as the Supreme Court has made perfectly clear. Quoting, the government should be prepared to share what it can concerning the steps it has taken and the prospects of further steps, close quote. The plain and active meaning of the word cannot be diluted by its construction as the government would have it to a narrow term of art. We are not bound in this context by a definition crafted by an administrative agency and contained in a mere policy directive. Thus, the government's argument that all it must do is remove any domestic barriers to Mr. Abrego Garcia's return is not well taken in light of the Supreme Court's command that the government facilitate Mr. Abrego Garcia's release from custody in El Salvador. Facilitation does not permit the admittedly erroneous deportation of an individual to one country's prisons that the withholding order forbids. There was a court order in place preventing him from being deported to El Salvador, and that's where the Trump administration sent him. And further, to do so in disregard of a court order that the government not so subtly spurns. Facilitation does not sanction the abrogation of habeas corpus, release the body, through the transfer of custody to foreign detention centers in the manner attempted here. Allowing this would facilitate foreign detention more than it would domestic return. It would reduce the rule of law to lawlessness and tarnish the very values for which Americans of diverse views and persuasion have always stood. The government is obviously frustrated and displeased with the rulings of the court. Let one thing be clear. Court rulings are not above criticism. Criticism keeps us on our toes to help us do a better job. Court rulings can overstep, and they can further intrude on the prerogatives of other branches. Courts speak with the knowledge of their imperfections, but also with a sense that they instill a fidelity to the law that would be sorely missed in their absence. Quoting a Federalist paper, energy in the executive is much to be respected. It can rescue from its lassitude and recalibrate imbalances too long left unexamined. The knowledge that executive energy is perishable quality understandably breeds impatience with the courts. Courts, in turn, are frequently attuned to caution and often uneasy with the executive branch's breakneck pace. And the differences do not end there. The executive is inherently focused upon ends, the judiciary much more focused upon means. Ends are bestowed on the executive by electoral outcomes. Means are entrusted to all of government, but most especially to the judiciary by the Constitution itself. The executive possesses enormous powers to prosecute and to deport, but with powers come restraints. If today the executive claims the right to deport without due process and in disregard of court orders, what assurance will there be tomorrow that it will not deport American citizens and then disclaim their responsibility to bring them home? And what assurance shall there be that the executive will not train its broad discretionary powers upon political enemies? The threat, even if not the actuality, would always be present, and the executive's obligation to take care that the laws be faithfully executed would lose its meaning. Today, the United States and El Salvadoran governments disclaim any authority and or responsibility to return Mr. Abrego Garcia. We are told that neither government has the power to act. The result will be to leave matters generally, and Mr. Abrego Garcia specifically, in an interminable limbo without recourse of law of any sort. The basic differences between the branches mandate a serious effort at mutual respect. The respect that courts must accord the executive must be reciprocated by the executive's respect for the courts. Too often today, this has not been the case, as calls for impeachment of judges for decisions the executive disfavors and exhortations to disregard court orders sadly illustrate. It is in this atmosphere that we are reminded of President Eisenhower's sage example. Putting his personal opinions aside, President Eisenhower honored his inescapable duty to enforce the Supreme Court's decision in Brown v. Board of Education to desegregate schools with all deliberate speed. This great man expressed his unflagging belief that the very basis of our individual rights and freedoms is the certainty that the president and the executive branch of the government will support and ensure the carrying out of decisions by the federal courts. Indeed, our late executive's own words, unless the president did so, anarchy would result. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. The judiciary will lose much from the constant intimations of its illegitimacy to which by dint of custom and detachment we can only sparingly reply. The executive will lose much from a public perception of its lawlessness and all of its attendant contagions. The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been, and law in time will sign its epitaph. It is, as we noted, all too possible to see in this case an incipient crisis, but it may present an opportunity as well. We yet cling to the hope that this is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that is within us while there is still time. That's a very eloquent way of telling the President of the United States to get his shit together and stop acting like a crazy person. In sum, for the reasons foregoing, we deny the motion for stay pending appeal and writ of mandamus in this case. It is so ordered. Signed, Judge J. Harvey Wilkinson III. This panel of 3 federal judges, including Judges King and Thacker, used the word lawlessness 2 or 3 times to describe the Trump administration in this case with regard to Mr. Kilmar Abrego Garcia, and told him to get his shit together, and told him in no uncertain terms that everybody in this country is entitled to due process, whether they are here legally or not. This is a beautiful thing, and it brightened my day immeasurably. I hope it did yours too.